Hello, I am Stephanie Joy, the attorney at All Things Social Security and Joy Disability Law. Your video is about to start. I just wanted to remind you that if you click the join button below, you can learn more about the memberships offered at a very affordable price that can give you a little more direct attorney answers to your questions. Have a great day and enjoy the video. Hey, so what's going on with the 5-year rule change down from the 15-year rule change on past relevant work? And how does it affect you? Let's just go over for a couple of minutes what it means if you are denied an initial or recon and you're heading to an ALJ hearing. You were denied because they said, ostensibly, maybe, that you could engage in a job during your past relevant work period, and therefore you lost at step 4 of the sequential evaluation process. So what does that mean? It now means when it goes to the ALJ, he's going to be looking at it from a different rule. So he will be looking, it will no longer be all the jobs you had in the past 15 years. It will be only those in the past 5. So if in the past 5, you were doing harder jobs that your medical records illustrate that you can no longer do because of certain limitations, functional limitations that stem from your proven impairments, then that job would not be available to you. So you would then pass step 4 and not be denied at step 4. And then you get to go on to step 5. Is there other work you could do? So the game is not ending on the positive necessarily, but it is giving you a wider range of possible winning space, okay, at the ALJ level. Now, if you were in the grid range where you were found you could do your past relevant work on initial or recon, and now you're heading to an ALJ hearing and the rule has changed. So this ALJ will be using the new rule. If it was found that you could do past relevant work and you also have no transferable skills, you fall into a grid, now the fact that you might be able to prove that you could not do your past relevant work because it only includes this many jobs instead of this many jobs, then that would be a win for you at the ALJ. For those that have had the same job for 15 years or 6 years, this isn't really going to help you. For those that in the last 5, let's say 10 years ago, you had the easier jobs, 15 years ago, 12 years ago. Those are the jobs that they can no longer look at for you. And that's where the benefit is. For those of you that had the same job the whole time, it's really not going to be a benefit to you because you did have that job the same job you had then, you had in the last 5 years. So it still has to be looked at. Is that making any sense? Likewise, and this is a little broader, but if it's a different job but has the same, exertional capacity or other requirements, even though it's a different job, but not much has changed in terms of those broader concepts, it might also be harder. But for those that had the easier jobs before, and that is what they said you could still do, they maybe said, yeah, he can't do his most recent job, but he can do that one from 8 years ago. You are the people that this is going to help. Okay. Now you do have to, when you go to ALJ hearing, you have to get your medical evidence really strong, be really diligent about following up with medical treatment and diagnostics, and verbalizing or messaging your doctors to, make it clear what your limitations are and how it's really interruptive of your day-to-day activities. And that's your day-to-day activities at home when you're not working, but they can be inferred, deduced, I'm not sure what the word would be, into what that would mean in the work life. And that's why that functional information, such as the function report, is really important. But make sure you build up that evidence because you still need to prove that you can't do the work you did in the last 5 years. So it's not escape for all, but it is huge. And for those of us that practice this day in and day out, 7 days a week, we know how huge of a difference this is. So anyway, I hope that clears up for you. What you got to do if you came out of initial and recon before June 22nd, everything now is different. Even if you're waiting for an ALJ hearing already, not just going forward, obviously this is going to help you. You know, it's a whole new way of looking at it. So I shouldn't say it'll help everybody. Like we said, it's going to help people who have this particular job history that's impacted with the past relevant work definition. Okay. Take care, guys. Later. Hey, so if the subject matter of the video you just listened to is of interest and you want more on it, stay tuned. Here's another one about the same topic, but a little bit different. Bye now. Hey guys, I have huge news. It came out just maybe 30 seconds ago to me. Got it in an email from my source, one of the major 2 organizations that report to us on Social Security and work really hard legislatively to get things accomplished and through the agency itself. Not too many months ago, I put out a video on the proposed rule change for past relevant work and what the SSA can consider when determining whether you, in fact, can do your past relevant work. There is a recency rule, and forever and a day, it has been 15 years. It's always been that. I've been doing this 2 decades, and it was 15 years, and it's still 15 years. However, they decided they wanted to change it to 5 years. This is so huge. I'm going to attach the video where we talk about why it's huge, so I don't repeat myself too much. But guys, this is the first big claimant-friendly, immense claimant-friendly rule change in my lifetime with this. I know during 15 and that whole era, they were creating rules that were really going to be harder for disability claimants, as well as for some retirees. And they succeeded in doing that, and a lot of things became effective immediately, and some in 2017 as a result. But this one is the pro-claimant, really getting a grip and understanding on the fact that a job that you could do, that you did 14 years ago, and you could probably do it now, is no longer going to sink your ship at step 4. So huge. Looking back 5 years, it's going to be really your recent work. You know, 14 years ago is not really recent, right? In terms of how we remember we did it. Are the conditions still the same? Are the technologies still the same? The processes, all that kind of stuff, the expectations of output, etc. So they've recognized and they're acting upon the fact that things have changed. And the rate at which probably jobs change and what's needed for a job, the rate at which they change can no longer be contained in a 15-year period. It is much quicker that things change. So anyway, this is huge. And we don't have to wait for 6 months for this to take effect either. It's taking effect June 8th. So what I don't know is, will it be affecting cases that get decided June 8th or after? Or will it be affecting cases that get filed June 8th or after? The final rule is going to be published tomorrow. Once again, we have a little early insight into it, which I really always appreciate. And when I find out that date, I will make sure that I post it in the comments or to the membership. If you're not a member, consider joining. And, you know, it'll let you know what kind of impact this will have if you have a current case, or certainly if you have a future case. It is momentous. It is huge. All right, guys, that's it. I'm going to attach the actual further explanation, which I did a few months ago, and I got wind that this was going to potentially be coming down the pike, and I reported it to you. And take a listen. I'll talk to you later. Bye.